is an agent of Mr. Mugo and is proven by the registrar's report R2, the person under 13, for Madva Wangari Karua, George Joroge, and Musa Omondi. That is the judge. He asks, wanted to know the user who logged in on 12 August 2022 at 001 hours. I will take you to R9. It's the registrar's report. I have not filed anything in reference to this, my lords, my ladies. And it shows there was no user. It's the registrar's report. I'm not going to give an interpretation. And I will say the comment under, by the registrar, a review of access laws did not show the user or any suspicious activity. The registrar was represented by an IT technical team. So it did not even request us to lobby the registrar, explain to the registrar. The IT team confirmed for itself. My lords, my ladies, they said there was suspicious activity between various dates. I'll take you to comment 4 by George Joroge. Agent wanted audit logs for user root during the election period. Logs were retrieved from 8th August to 29th August 2022, the day before the election and the day before we did the exercise. There was no suspicious activity. I would like the court to do a simple thing, my lords, my ladies. Compare the logs Mr. Mugo has provided and what is found in the registrar. You will discover there is an apparent discrepancy on the face of those logs. Nothing put on the slideshow is in the registrar's report because it's not. He may clarify where he got that, but he'll simply refer to the registrar's report. It's not, my lords, my ladies. Now, when you move over the report, you get other clarification by other users, and I want to pick 3 that are quite pertinent. They say there was no way of ascertaining the date of the server log, and that was the opening comment. At page 22, comment 8 by Victor, agents wanted to know when Form 34C was uploaded. This was established to be 16th August 2022. How could have it been created on 31st August, but you are able to go back in history to 16th August to determine when Form 34C was uploaded? It's ridiculous on the face of it. My lords, my ladies, I'll take you to George again, page 23. The agent requested to see the whole architecture. The whole, not only RTS, not only KIMS, the entire IBC infrastructure, including everything retained in that server. IBC database admin presented the system architecture and explained the transmission flow. How can you say access was not granted when it was granted the entire architecture, not RTS? My lords, I notice my time is running, and my senior wanted to refer to the forever. I will stop here, but if given time, we can take the court through the entire report and answer every query raised satisfactorily, because it was done. Access was granted, that's why comments were made. If access was denied, there would have been no comment. Thank you, my lords, my ladies.
If it may please you, the Honorable the Chief Justice, the Deputy Chief Justice, and other distinguished members of the Supreme Court. My name is Emmanuel Wetangula. I'll be presenting our observations on behalf of IEBC with regard to the scrutiny and the recount that took place on the 31st and yesterday, my Lord. First and foremost, I'd like to thank members of the judiciary who took part in this exercise. It's the most tedious and laborious jobs, and not the most, and most people actually opted to run away. And even in the submissions which I'm about to make before the court today, it will be quite notable that none of my colleagues have addressed the pertinent issue. All the results in the boxes matched the results that have been declared by IEBC and the results that were used to declare the president under Article 138.10. My Lord, I'll simply give one example. The application for scrutiny was given by the petitioners, and they identified the stations that they wanted. If this was to be a sample of the entire election, the report bears out the fact that out of the 45 polling stations that were counted, there was no variance of results in the 40 stations. 40 of the polling stations. The report clearly shows that there is no variance of the results with that which was contained in Form 34A. But most importantly, my lady and my lords, there were slight errors which will arise, and it always arises in every election. It's typical to human error. And even to point out this fact, my lord, I was reading the report that was prepared by the Honorable Deputy Registrar. It also has a slight error. And that error was corrected today when we were sent an addendum correcting a mistake that had been done. Number 2, my lady and my lords, at page 31, you will note that there's a slight typographical error regarding the date of the election. It's indicated as 8th August. Error that any human being will make. But if it were the petitioners, I'm sure they will pray that the entire report be disregarded. But my lord, the most important thing is the environment under which elections take place is a very tense situation. And many a times, slight mistakes will occur. For instance, the sealing of documents, the misplacement of one or two things. The only complaint I've had my learned colleagues, Mr. Awele, complain about, Ms. Mboshe, and Mr. Willis Otieno. It's about material not being placed in envelopes. But of utmost importance is, having been present with every ballot that was counted, it tallies with what was given to each of the candidates. But most importantly, the allegation the petitioners have made and have been running around with is that election results were being taken from one candidate and being added to another. That fact was not proven. This is their case. And if at all there was any variance in the results, I believe Mr. Willis Otieno will have sung for us a new song today, but he didn't. And that confirms that actually the results are believable. And my lords, these are the results that were transmitted through the results transmission system, first and foremost, having been final. Secondly, these were the results that were physically delivered by the returning officers to the tallying center at Bomas. And my lord, if the registrar confirms that from the boxes that the court has sampled, there's absolutely no variance, then we wonder what the complaint is. The slight variances that, or slight mistakes that were noted, which I will just highlight one of them, that one of the parties picked up on. This is number 38 on the list of the polling stations, Kiheo Primary School. One of my colleagues for the petitioners made reference to it. Despite the absence of the counterfoils, but each of the ballots present matched with the result that was declared for each of the candidates. I wonder how accurate an election can get if this is not it. But mistakes will always happen. And even in the report that is before us, we have noted that actually mistakes actually do happen, and they happen all the time. There was something else that the parties were supposed to deliver, that is IABC, which was Forms 34A. My lord, a sufficient volume was delivered to the court. I'll just confirm how many there were. There are 32 volumes of Form 32As which have been availed to the court. My lord, there's also the error form, 3 volumes which have been availed to the court for scrutiny, signed by the chair. These are the errors that were noted during the verification and tallying. And lastly, my lady and my lords, before the time runs out, Book 2 of Form 34A, some of it was found in the ballot boxes during the scrutiny, but some of the boxes did not contain, and it's borne out in the report. But the purpose of printing this booklet is actually known to all the players. My lady, my time has run out. I'll just request for 2 minutes to finalize my points, and I'll be done. Thank you. My lady, with regard to Form 34A, Book 2, the purpose why an extra copy was printed, and it's known to the petitioners, but they will not tell this honorable court, was that at any time, sufficient copies of the forms will be available to the agents, candidates, and the media. This is to ensure that the results that were being declared at the polling stations being final were transparent and known to everybody. But a contest arose and a decision was made by the chairman of IEBC that this material was to be sealed and placed in the ballot boxes. As it will happen, in some of the boxes, and the report will bear it out, some of the forms are not there. And even the report will bear it out that some of the presiding officers made mistakes in book 1. They cancelled it and utilized book 2, but still the result did not change. What is important and material is from the scrutiny that was undertaken until very early hours of yesterday morning, the result matches what is contained in Form 34A. And my lords, those Form 34As have been availed to the court pursuant to the rules of the Supreme Court, and they are the forms that were used to declare the results of the election upon the completion of the exercise. Similarly, these are the same forms that were transmitted through the results transmission system, and they match each and every other form that was given. Lastly, and very lastly, there was in one station in Kakamega where the Form 32As were not availed, and affidavits to that effect have been given, and the reason is that because of an outbreak of violence, the affidavits will bear it out. With those few remarks, my lady and my lords, Professor Mugai is asking for a donation of the time, but it has run out. Thank you very much.
Lady, without appearing to interrupt the court's proceedings, with that kind permission, my learned friend has made reference to an affidavit that was given. You've never been supplied with that affidavit. We don't even know about it. And I don't think it is proper for evidence of that such a nature to be brought to court at this critical point. And I wish the court should ignore it.
I don't think we are aware of it because we closed the filing of proceedings in this matter.
Very kindly request you to allow me to place on record that we reserve our right to object to that document filed by my learned friends. First, because it was filed without leave. Secondly, because no other party has had the opportunity to do the same. Thirdly, because from what we hear now, it may very well contain falsified documents.
Yes, have we had submissions from the main respondent, but now in the yes. Yes.
Madam Chief Justice will be making a formal application for the document tendered by Learned Counsel Mr. Mulgo to be expunged from the record. But first things first, we shall respond pursuant to the order issued by the court. We were to orally respond,
Yes.
not to use that opportunity for other filings. On our part, two of my colleagues will make the oral submissions. Please, that was not within the, please allow us the 15 minutes. We hadn't started making the submissions.
If it pleases the court, my name is Omwanza Ombati. I'm going to present the first part of or the comments about the scrutiny report, and the second part will be presented by my learned friend, Senator Hilary Sigei. My lords, it's important to first appreciate that the purpose of scrutiny is an exercise that is meant for the court to have an impression of how the exercise of the election was conducted. And that's what you said in 2013, Raila. And secondly, also it's important to note that part of the process of scrutiny is to audit the election and make sure that the numbers are backed up by the paper trail. In the request for scrutiny that was done by the petitioners, my Lord, Chief Justice and members of the Supreme Court, the request was targeted. You'll find that particularly in petition number 5, and also the affidavit of Arnold Oginga, paras 81 to 91. That is where the scrutiny was ordered, and when you retire to consider this matter, my lords, I request of the orders that was given by this court. You'd find that there are 7 orders. I'll deal with order number 1 to 4. The first one was with respect to an order that IBC should provide the applicants with copies of the technology system and security policy. This was complied with, except that the applicants also wanted the specific names of the system administrators. My Lord, this will not be possible because then you would expose system administrators to danger. The second order is with respect to a supervision of the servers, to have access to the servers of the National Tallying Center, to demonstrate how Form 34C was dealt with. The forensic image of the 34C was granted, and all parties were also given time to interact with this server the whole day. Now, the third and more important, part of that order also was to see whether there was any deletion of any Form 34A at the server. You'll find that at page 21 of the registrar's report. There was no deletion. There is not a single deletion of a Form 34A from the server. And my Lord, Justice Lenola asked a question on how was it that JPEGs were converted from JPEG to a PDF. My Lord, that answer is found at the registrar's report at page, it's a short page because a lot of issues have been raised about this. You'll see whereby it says that the Form 34A, you'll find this at page 12 of the registrar's report, that the Form 34A would be scanned by the KIMS kit into a PDF, which was then transmitted into the storage server. At the storage server, the form is processed by an application to check for compliance, to certify that the security features have been complied with, and the PDF has all the features that are supposed to be there. That goes also to page 13. This is important because, my Lord, there was a theory of the middleman that was being propagated by one of the petitioners, and in this scrutiny we could not find any middleman. In fact, there was a direct link from where the results were transmitted. So the transmission was from the KIMS kit. It would go to the National Tallying Center. One form would go to the National Tallying Center. The second form would go to the constituency Tallying Center, and the third form would go to the portal. And in this path, results path, there was no middleman. That was the smoking gun that was used by the petitioner, and my Lord, unfortunately, there was no smoke, and there was nothing that would find that was found in that. It's important, my Lord, to demonstrate to this court that in the scrutiny, there was first compliance by IEBC about, in terms of the orders of this court, order 1 to 7, as far as was practicable. And number 2 is that in the case theory that was presented to this court completely collapsed. we are all aware and we saw it, that the petitioner brought a case that was packed in a truckload. However, when that was subjected to scrutiny, it collapsed like a house of cards. So, my Lord, the scrutiny has demonstrated that this election was conducted in substantial compliance with the law. If there are variations, they are minor and they do not materially affect the result, and we submit that this court should validate the win of the first and second respondent in terms of Article 140 of the Constitution. I would conclude and say that from what we've heard, my Lord, it's important probably for those of us who didn't go to the schools that my friend Ayatollah went to. If you read the book of Macbeth, the play of Macbeth, the second play, you'd see that there's a debate. There's a debate about the devil and conscience. I think in one of the last acts, about a servant who's known as Lancelot, and this servant has this big debate on what is it that he has the devil that is pushing on him and also his conscience, and he concludes that he would rather go. In fact, I quoted this because it's very interesting. He says that my conscience is hanging by my neck, the neck of my heart, and in my conscience is a hard conscience. However, the devil gives me a more friendly counsel, but I choose to run from that friendly counsel. My Lord, with those few remarks, I will request that my learned friend, Senator Hilary Sigei, can continue.
The Honorable Chief Justice, the Honorable Deputy Chief Justice, and the judges of the Supreme Court. My name is Hilary Sigei. My remit in submitting on the basis of the report is limited to the numbers. And my lords, I would dare say, fiction is best told in abstract. My learned colleagues for the petition have taken you through what they called a product of scrutiny. They have intentionally left out what is also equally important besides the process, and that is the numbers. I associate myself largely with the submissions by my learned friend, Mr. Wetangula, particularly with regards to the numbers and the 45 polling stations, which was a subject of inquiry in the orders for scrutiny. Given, my lords, that the election process in Kenya is a process that we are conducting 6 elections in one day, it is natural that errors, especially in counting, tabulation, are bound to occur. But far from that, when the 45 polling stations that this Honorable Court directed that a conduct of scrutiny be done, the recount confirmed that there was correct vote count in 45 polling stations. It also confirmed that all the data that was entered, including, for example, the rejected votes, reflected that which was in the ballot and that which was in the image. It also confirmed that the Form 34As were not altered as it has been submitted before you. I therefore do submit that there are no irregularities in terms of the votes cast against each of the candidates in this particular petition. There was also no transposition the way they had placed that votes from candidate A was taken away and given to candidate B. That product of scrutiny has confirmed that. To be very specific, in Mombasa County, Mvita, polling station 1 of 7, all of them had no variances at all. And in the fullness of time, this Honorable Court, I believe, will spare a moment to look at pages 36 to 49 of the report from the registrar. Majengo, 2 polling stations, no variance, that is page 50 to 57. Mikindani, polling station 1 to 9, no variances were detected at all. In Kericho County, Chepkutung polling station 1 to 3, no discrepancies were found. In essence, what I'm trying to submit, my lordship, is that the numbers complied in terms of what each candidate had been given as at the time of the tabulation at the polling station and what has been provided and availed before you. I am aware that the 32 volumes of Form 34S are placed already before you. Elections and the will of the people is deposed in the polling station as per the minor Kiai case. I urge your lordships and my lady to indeed look at the 32 volumes of Form 34S placed before you, do a comparison with the 45 which we have submitted, and a report has been placed before you that numbers did not change. If they could not impeach on the 45 polling stations that they pleaded, they cannot impeach on the rest that are available before you. When we look at the other stations they have talked about, Nyandarua, Kiheho, my learned colleague, Mr. Njomo, indeed confirmed that materials were all there in the ballot boxes which were opened. His concern was that they were not placed in tamper-proof envelopes. He's also confirmed that the numbers in those polling stations are there. Those were the submissions by Mr. Njomo on behalf of the petitioners. As regards Oljororok, where he quoted that there were no seals placed, when you look at the report of the registrar in that particular polling station, appearing at page 141 to 171, no polling station had variances in terms of the numbers that were awarded to either the petitioner or my client. In short, my lordship, I submit that there is no evidence that has been placed before you to impeach the forms 34A, which are already before you and which are in the portal, and which actually is where the vote from the voter, where the voter is expressing their choice of the candidate whom they would want to place in the executive office, was done. No wonder Kenya has moved on. I want to beseech this honorable court to allow that which the people of Kenya made as a choice on the 9th and declared on the 15th to be the choice of the leadership they would want to lead this country for the next 5 years. I am a product of that particular election. The Honorable Madam Chief Justice, allow me 1 minute to close. Thank you. I wanted yesterday, while Malanet Senior, the Honorable Attorney General Emeritus, invited you to ask the Honorable James Orengo and Professor Tom Agenda, I would invite myself to answer that. I am a product of that election that was conducted, and I am aware that if one is clear, the rest will be clear, as we have attempted and have indeed proved in the submissions that are before you. I request and I plead that this Honorable Court upheld the declaration that was made on the 15th of August 2022 of the presidential elections. I thank you for the time, and thank you. I will donate the remaining 13 seconds to the court. Thank you very much.
Thank you very much, Council, and I think we congratulate all of you who have been elected to the new office and wish you well.
For you, I am mandated by my colleagues, and I hope on this one I also speak for my very dear and distinguished friends on this side.
We haven't finished. We haven't finished.
We haven't finished.
Oh, you haven't?
Yes.
Sorry, I wanted.
Yes. Sorry, we wanted to say that we cannot accept these documents, unfortunately, because we had closed the filing and we had indicated that we will take oral submissions on the report by the registrar. So the application to expunge them, I think it's around, they were not even filed, they were not accepted, our system did not accept them. I think there is one clarification also from the bench. Justice Fenara?
Yes, thank you, President. Mr. Murgor, let's go to R10. R10 is users who logged in recently. On this registrar's report, you projected it. So the one which has the Vito, Gudino, Vito, Provisio, Silva, Ogudino. Do you have it?
You would like me to refer to my report?
It's a document. I'm looking at this registrar's report, so if you have it on yours is blank, I'm sure, if you noticed. Yes, that one, yeah. Yes, so go to, not that one. Page, it doesn't have pages, but it's an extra R10. It was the foreigners' logs. Mine doesn't have pages.
I don't have it.
It just reads R10. Anyway.
Yes.
R10 is titled Users Who Logged In Recently. Do you remember that? You projected it here.
We projected it, yes.
Yes, so Vito logged in on July 28th. That's my question. I want to see whether we're on the same wavelength as to the dates. Because you said they logged in during the tally. Does someone have a copy of the report?
We can share a copy.
You can use this. Please share a copy. Take this. R10. And to save on time, Mr. Ngarisha, you can be looking at R12 yourself.
Yes. Thank you. Okay.
So, Mr. Murgor, you said in, if I...
That's all.
R10.
Why don't I have this? Okay. Yes.
Yes, so R10, please read for us the dates that these people logged in and the time.
The R10,
yes.
I have the logs start from July 20th to July 28th.
Exactly.
Yes.
So did I hear you saying that they logged in during the tallying period?
That's what I had in my document that I filed.
We are looking at the registrar's report. How different is your document from this one?
I will check because what we have has those logs.
Remember, we are working with the registrar's report, not any other document. That's why I was getting confused.
This is probably the reason why we filed our own document, because you have extracted, or the registrar has extracted this part, we have extracted the entire. So we could look at what we have.
Yes.
I will speak to the IT people and clarify that.
But
because our logs start from July
but
to
for the registrar's
August.
report, it's July 20th to July 28th.
Yes.
Okay, so I just want to clarify that. That was before the election, therefore.
That was before the election.
Thank you. That's all I wanted from you. Mr. Ngarisha, let's go to R12. I would have expected you, as you come, to answer Mr. Murgro's concern, which was that R12 is a history of delete and removal actions. Mr. Murgro's concern was activity, and you look at the dates, it is 6th of August at the bottom, and then a lot of activity happened on the 31st of August. I would have expected you to say these deletions and removals relate to this action. Mr. Murgo is saying, following the, and now I think we can disconnect R10 from R12, but I'm concerned about R12. What activities were these? What was being deleted? What was being removed? So that you can get Mr. Murgo's point, which is quite of interest to me. I thank you.
My Lord, far be it from me to correct the court. R12 is a series of command that was firstly executed by the IBC database manager. I refrain from mentioning her name. She has her own security concerns, but her name appears on the record. Then, that is, I would say, if you look at the page, from 58 to 72 on your left, that is the command running. If you look at R12 on your left, my Lord, there is 58, 59 running. That's the command running, showing there was no deletion. If it was put on the screen in color, you will see what then we did once we realized there was no deletion. Mr. George had a specific command, which he said you can delete or remove from a server. Like in a computer, you can either press the delete key or you can press shift delete. So you can either delete or remove permanently from the server. That command was executed. And my Lord, be it far from me to comment on this. The registrar at page 21, James, Khalifa agent wanted to know if a root user has deleted or removed any file from the server. No records of file deletion or removals were discovered. I could interpret the code where you have 72, it shows the library Docker. You have a server which has various compartments called containers. These containers connect to the server by what we call a Docker. It's just an interface for exchanging the communication. It just is up to there. It cannot find any deletion. Then they executed a graphing. Graphing is where you limit the search range. Maybe you wanted to go to the registry and ask how many matters were filed in June. If you ask the registrar how many matters have been filed, you will maybe start from January to August. But if you ask what files were filed in June, that is the graphing. And that's why you see when you read it, it has a graph. Graph, it's not GREP space rem at root after number 72. There is root, application runs. It looks at the log history. Let me, if you will indulge me, let me explain it, my Lord. After 72, the root application, which is in that specific container, runs the log history, then it's graphed for remove. Is there any history of removal? There is none. Mr. George then requests, let's check for delete.
That is all I wanted to hear. If you say there's no deletion, that's it. I think we understand what the point is.
And my Lord, for R10,
yes,
I could clarify if you'll indulge me.
Go ahead.
If you look at the entire logs, there's what you call an IP address. There's a public IP, and there's an internal IP. The judiciary has its own Wi-Fi that it runs within the court. It has an internal network. Then there's the World Wide Web, where everything that everybody can see. All those IP addresses, compare with all the IP addresses in the entire report by the registrar. They are internal IP addresses when IBC was being supported. The same way, if you had an issue with your laptop, you'll take to the judiciary technician. They were being supported because they purchased a software and they needed routine maintenance. And my Lord, before you say this is my own assertion, I will take you back to the registrar's report, whereby they searched between August, the entire month of May to August, for any deletion, removal, there was none. Then they searched for the entire August, whether those users accessed. The answer was none. I will adopt this report in entirety. See, for maybe a few comments I would have, but that's bickering over the minute time, my Lord.
Thank you very much.
Much okay.
Thank you, CJ.
My Lord, just a quick one. The page you refer to as R10 appears to look very similar to this page 16 that I had provided. All I'm saying is that relates to dates in July, and what we received from IBC contains logs up to the 31st of August. But the two last entries in August 31st and 24th are attributed to Root, who we believe is one of the same gentlemen. But the one I referred to today was August 16th. So it's just a question of how long the log was. Check again on your side. And then finally, on the issue of the deletion, our position is that there was obvious deletion, and what we found there was empty, recently modified file, and certainly not a server that could hold the entire election in the Republic of Kenya.
Thank you very much.
I want the record to show, with your very kind permission and the concurrence of all my distinguished friends, learned friends, particularly those to my right who have accorded me the honor of making this speech on their behalf. We thank you most sincerely for all the time and effort that you have put, and your patience, and putting up with some of our not very honorable conduct. We apologize for that, and we wish you good deliberations. Thank you.
Thank you, Senior Counsel Professor Gideon Muigai, Attorney General Emeritus. From this end, and before our team leader speaks, we want to thank you for your assistance to us in the last 3 days. We want to say that if there was bad manners, we didn't see it. These things happen, and there really wasn't bad manners. We thank you for working within the very strict timelines that we gave you. Now, if you felt pressed for time, blame yourselves, because you gave us 14 days to do what ought to be done in a year, if you ask us. And while you take a break today, we continue working. We thank you, truly thank you on behalf of the team and before the team leader speaks. What you didn't know, but you may have realized, is that every day there was a marshal or a prefect from this end to ensure that you kept to your lanes. If you didn't notice, today I was the marshal. The day you laughed most, Dr. Wanjala was the marshal. That's how we work here. We work as a team. We divide roles here so that we don't all speak at the same time. And here, like things we have heard you say today, we consider ourselves equal. None of us has a veto power, but of course we have a team leader. We thank you very much. Pray for us as we undertake the next phase. It's actually not the more difficult one. You have helped us with the more difficult part, but it is intense, for which reason, therefore, we ask you that you pray to whatever God you pray to, that God will assist us to continue in the spirit we've been in for the last 1 year, and that we shall have a very high sense of discernment, and that we shall return to Kenya a judgment not less than what Kenya expects. Thank you very much, and now I ask that the team leader speaks to us.
Thank you very much, the Honorable Vice President of the Court, and for being a very, very effective marshal for today. Allow me to thank my brother and sister judges. We actually call it shared leadership in the judiciary. We take up all this responsibility together, and I'm most grateful for that. Thank you, Senior Counsel Professor Gebu Moigai, for those very kind words. All we saw, like the DCJ is saying, is very, very robust arguments and participation. We did not record any bad behavior. Like you see, we did not cite anybody for contempt. So we are very, very most grateful for your cooperation. Allow me also to thank the other people who worked with us round the clock. A team led by the Registrar of the Court, Honorable Letitia Washira, and the Deputy Registrars, our law clerks who have been supporting us, all the registry staff, the executive officers, and the court assistants. We also want to recognize the role played by our security, our police unit, and all the police officers and security people who have provided us with security around the clock to make sure that these proceedings move on smoothly. I may not be able to mention everybody, but also to say that anybody who did something to make these proceedings move smoothly, we are grateful to them. We also want to thank the international and local observers who came to observe these proceedings. We are grateful for your encouragement, and we continue to ask, like the Vice President has said, that you continue to pray for us so that we can render judgment that promotes our constitution, that is anchored in the law, that nurtures our democracy, that brings harmony to our country, and everything good that is stated in our constitution. So with those remarks, I will wish you a very nice evening, and as we retire ourselves to continue working. Thank you very much. I'm told that we will deliver our judgment on Monday the 5th. We shall give you notice closer to that day. I don't know, we have only tomorrow and Sunday. But we'll give you notice indicating the exact time when that will be done. It will definitely be on Monday, but I'm reminded that Monday lands up to midnight. So you'll be given the time indication in the notice. Thank you very much. Have a very nice weekend and nice evening.
No, we have spoken through our... So next week... Yeah, even now, there's a question I had told the team to work on, which is now petition. That was the impact of incorporation just returned from
End of the 3 days of submission at the Supreme Court, the last of the submissions being made this afternoon. But now what will happen is a different date will be given, time rather, on Monday for when we will have the Supreme Court rule on this. I see a lot of excitement from members of the different parties here. Well, it's a picture moment right here for the parties that have participated in this election. Have done their best, so what remains is the adjudication from the judges. See exactly what's happening, because it's been a great day for everyone here. And of course, now what they wait for is the judgment, everyone hoping that it favors their side, putting their best foot forward. That advocate, senior friend Gatia, telling me that the document has been expunged. I mean, that was the basis of their case this afternoon. Everyone had to ensure that they do their best to make their case. But the long and the short of it, it's been 3 days grueling procedures at the judiciary, the Supreme Court majorly. And the most important thing is myself as Ken Mijunga have had an opportunity to cover this in 2013, 2017, and now in 2022. There can only be two possible outcomes out of this, but we wait to see what exactly the judges will say when the time comes to call this. I think it's gone well. We don't need to belabor much. The lawyers were in court and they have said what they have said, and definitely they hope that they've done their best. So from where we stand at the Supreme Court, nothing more to say. We can't speak to the issues now of law. This is because there's a lot of excitement here. If you can see the pictures and the different teams taking pictures, celebrating what they believe will give them victory. So will William Ruto remain president-elect and wait for the swearing in on the 13th, which is the most realistic time, 13th of September, or things will change? We wait to see as this court sits to deliberate and return their judgment next week on Monday at an appointed time that they will communicate on Sunday. They have the whole time until Sunday afternoon or Sunday evening to make that date known, and definitely we'll be covering that also for you. But this is the pictures, or the perfect picture of the team that has been representing the 9 respondents, all their lawyers coming together just to say goodbye as they leave. So it's been a good run for all the lawyers, and definitely they hope for the best from both teams. A lot of excitement, I have to say, a lot of hope. And if they presented their cases before the Supreme Court, well, if they made a point, if they managed to convince the Supreme Court, then I must say that the verdict, whatever it will be, it can only go either way, to favor them or not. So that's it from here at the Supreme Court of Kenya. It's been a privilege once again on behalf of the whole Standard Group team covering this for you. I did this in 2013, 2017, and once again we have an opportunity in 2022 to hear this. Definitely the whole world is watching. Can Raila Odinga manage to do what he did in 2017 in 2022? Can he get the court, can he move the court once again to nullify this election, or this time round he will not be two-time lucky? but it all depends on how they move the court, what they told the court. If it convinced the court, issues of law, issues of fact, numbers just like facts don't lie. We leave it here. Thank you for watching KTN News. We are back to court on Monday when this pronouncement will be made, when that decision will be made, and when the ultimate decision that will propel Kenya forward will be made. Will Ruto be president-elect the 5th, or will Raila Odinga get an opportunity? Will he to go back to the election and ask for votes? Thank you so much for watching on behalf of the whole team. Back. My name is Ken Mijungu. Back to studio.
KTN News. Get the whole story.
Laikipia County is one of the 47 counties of Kenya located on the equator in the Rift Valley region. Economic activities in the county consist of tourism and agriculture, chiefly grain crops, ranching, and greenhouse horticulture. Acquit, in partnership with the county government of Laikipia, with support from UKAID Digital Access Program, has been implementing the sustainable and digitally enabled agriculture for enhanced food security in the county. The project aims at increasing access and utilization of locally relevant digital agriculture content.
Submitted to the National Tallying Center and has uploaded to the Form 34Bs and 34C. That was used to declare the result in Form 34D, my lords. My lords, granted further that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman, but the commission that was required to undertake that process. And my lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my lord, that the commission shall undertake the process, not the chairman. The same term, my lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My lord, if I may just read 138(3)(c. It provides, my lords, that the process of tallying, my lord, after counting the votes in the polling station, the independent electoral and our shall tally. My lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my lords. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138.10 alone without consultation invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)C of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)D of the Elections Act. My Lord, going forth, the complementary nature of compliance, sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the Commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the Commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim ex turpi causa non action, which has been developed over the years, my Lord, by Lord Mansfield initially in Holzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, the principle, ex equo et bono, used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellively apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my Lord. My Lords, the maxim, amiable compositeur, that I shall look at after my learned friend Mr. Omtata presents the results, my Lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my Lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my Lord.
And now a senator? And now he's a senator?
Yes, a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others, which is dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit which is dated the 29th of August. My Lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election
does not meet the threshold in the Constitution at all. The presidential election, the one I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where the...
If the time could stop running, we had supplied the electronic instruments to the court.
You beg the assistant.
I don't. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. It is the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. We've got the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But it has come out it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate their raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious from paragraph 32 of Mr. Sunkuli's replying affidavit. So when you go on to the next slide, I've reproduced I've tried to factor in the figure that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavits, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137,000, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evident to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I go to address the question of whether you can achieve, assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50%.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. the next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
Two, 3, 4, 5, 6, 7, 8, 9. Melon, 100. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 110. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 120. 1, 2. 120.